As a physical security professional, your job is to protect people and property. But what happens when those two things are in conflict? Today, we're breaking down the essential legal rules every security pro has to know to design effective systems and, just as importantly, stay out of court.
All right, let's dive right in with a classic security dilemma. Imagine it. A thief is picking a lock, but at the exact same moment, a fire alarm goes off. What's that door supposed to do? Lock down to stop the bad guy, or unlock to let innocent people out? And look, this isn't just some textbook question. Your answer to this is the absolute foundation of all legally sound security design.
And the answer? Well, it's actually super simple. It's the golden rule of our industry. Life safety always trumps security. Always. This is the one principle that cuts through any confusion, any conflict between what you want to do for security and what the law says you must do. If you only remember one thing from this, make it this.
So what does that golden rule actually mean when you're on the job? It means you can never, ever, under any circumstances, trap people inside a building. I don't care how great the security reason seems. When it's your brilliant security design versus the fire code, the code wins. No exceptions. Every single time. And this is where you, the security pro, really earn your paycheck. Your job isn't just to bolt things down. It's to be a problem solver. The fire marshal says people have to get out, no questions asked. So how do you secure that door? Can you use alarms, cameras? Maybe some clever delayed egress hardware that meets code. That's the challenge.
Okay, so what happens if you don't follow that golden rule? Well, that can lead you straight into the biggest legal nightmare you can face, a lawsuit for negligence. This is what happens when a system you designed or signed off on fails, and someone gets hurt because of it.
Now, for someone to sue you for negligence and actually win, they have to prove all four of these things. It's like a four-part test, and they can't skip a single question. They have to prove you had a duty of care, that you breached that duty, that your failure was the proximate cause of what happened, and that there were actual damages. If their lawyer can't prove even one of those, their case just falls apart.
Okay, let's dig into that first one, duty of care, because there's a really important idea in there called foreseeability. You know, the law doesn't expect you to be a mind reader, but it does expect you to protect against the kinds of risks that any reasonable person would have seen coming.
So how do you know what's foreseeable? It's not like you have an actual crystal ball, right? Well, the courts use what's basically a crystal ball test, but your crystal ball is made up of data. You have to look at the evidence. Have there been break-ins here before? What did the local crime stats say? Has there been a string of robberies down the street? That's your crystal ball.
And this right here makes it super clear. Look, nobody expects you to plan for a random meteor strike hitting the building. That's unforeseeable. But a car getting stolen from a parking lot where 5 other cars were stolen just last month, that's not a surprise anymore, is it? That's a pattern. That risk is now foreseeable, and you legally have a duty to do something reasonable about it.
So that duty of care we keep mentioning, well, it's not a one-size-fits-all kind of deal. The level of protection you're required to provide actually changes based on who is on the property. Let's break it down. At the very top, you have an invitee. Think customers, your employees. You owe them the highest duty of care. You have to actively look for dangers and fix them. A step down is a licensee, maybe a salesperson or a social guest. You have to warn them about dangers you already know about. And way down at the bottom, the trespasser. You owe them the lowest duty, which is basically just that you can't intentionally hurt them, which, by the way, means no booby traps. Seriously.
All right, moving on from the big legal ideas, let's talk about the nitty-gritty stuff, the specific codes and regulations that can just totally wreck a security design if you don't know them. We call them design killers.
Higher codes, like the big one, NFPA 101, are all about one thing and one thing only: getting people out safely in an emergency. That means you can't have storage blocking an exit path. An exit door has to open with one hand and one single motion. No weird twisting and pulling. And critically, if you're using electronic locks like maglocks, they have to be set to fail-safe, meaning they unlock the second the power gets cut by a fire alarm.
Then you've got the Americans with Disabilities Act, or ADA. Your security can't create a roadblock for people with disabilities. Simple as that. If you install turnstiles, you've got to have a wider, wheelchair-accessible gate right next to them. And things like card readers or intercom buttons, they have to be mounted low enough, usually no higher than 48 inches, so someone in a wheelchair can actually reach them. And here's a number I want you to remember. 5 pounds. That's it. Generally, that's the maximum amount of force an interior door should require to be opened. It's a tiny detail in the ADA code, but it's so easy to get wrong, especially if you install a big, heavy security door with a powerful door closer on it.
Okay, let's talk about privacy. This one should be common sense, but you'd be surprised. You cannot put cameras where people have a reasonable expectation of privacy. Think bathrooms, locker rooms, changing areas. Just don't do it. But where you can really get into hot water is with audio. The laws around recording conversations are way, way stricter than video. Honestly, the best professional advice is almost always the same. Just don't record audio.
So, what do? The client is breathing down your neck, telling you to just lock that fire door or install a reader that's too high. They insist. Your response needs to be simple and immediate. You document it in writing.
This email, right here, this is your legal shield. It is your most powerful tool. You professionally state your advice, you name the specific code you're worried about, and you get it on the record that they are choosing to ignore that warning. What this does, legally, is create a paper trail. It shows that the client knew the risk, and they decided to assume that risk themselves. This can shift the liability from you to them. Send it, and then save it. Forever.
So, we've covered a lot. The golden rule of life safety, the 4-part test for negligence, and all those little codes that can trip you up. You have the framework now. So, the real question I want to leave you with is this. Thinking about the systems you manage right now, which part are you going to go back and reevaluate first?